I don't know how the Conservative members of that Aboriginal Affairs Committee can continue to listen to witness after witness after witness telling them, do not go forward on this. We do not agree. And that those Conservative members of Parliament continue to not hear anything that's said at committee, not hear anything that's heard in consultation, and press on, forcing through legislation against the wish of the First Nations in this country.
It is a pleasure to rise in this House to support Bill C-9, First Nations Elections Act. As with everything we do as a government, this bill is about delivering results for Canadians and addressing the priorities of Canadians. That most certainly includes the priorities of First Nations citizens of this country, citizens currently living under the outdated and discriminatory Indian Act. As the matters this bill addresses are a priority for First Nations. This bill is about empowering First Nations across Canada to take charge of their own destinies. In fact, it may easily be said that this is not a government bill, but a First Nations bill. The government did not go to First Nations with a proposal. First Nations came to the government with one. Here is a serious problem, and here is how you can help us solve it. Bill C-9 before us today is not the result of the government consulting with First Nations. It is the result of First Nations consulting with First Nations. And it is difficult to imagine a more laudable goal than ensuring all First Nations citizens have the opportunity to participate in free and fair elections. However, the fact is that for many First Nations governed by the outdated and archaic Indian Act, the most basic premise of democratic government does not exist. Adoption of the proposed electoral system described in this bill is voluntary. This bill is intended to provide an option for First Nations that may not have the capacity to develop their own community election code, or that simply want a turnkey and accountable election code that they can opt into. Consider some of the shortcomings this bill will address. The Indian Act, for example, specifies that chief and band councillors are elected on a 2-year term. This is hardly conducive to the design and execution of the long-term strategies needed to achieve key priorities. It also means First Nation communities are in almost constant election mode. By the time a First Nation council has been elected, sworn in, got a handle on its responsibilities, and started the actual process of governing, it is time to start campaigning for the next election. Bill C-9 will enable First Nation communities to fix that by implementing 4-year terms for elected officials, bringing them into line with what is the norm for most other jurisdictions in Canada. In addition, this bill would enable different First Nations to hold their elections on the same day, a common election day. This innovative idea came directly from the Assembly of Manitoba Chiefs, and it's a good one. With terms of office beginning and ending at the same time, common election days would make it easier for groups of First Nations to collaborate and present a common front in business development endeavours and other shared priorities. The sort of checks and balances that allow most Canadians to take for granted the results of an election as an accurate reflection of the will of the people are virtually non-existent in the Indian Act. Similar to the provisions of the Canada Elections Act, Bill C-9 contains provisions that will minimize the likelihood of corrupt election practices by setting out specific offences and specific penalties for those convicted of committing those offences. Instead of appealing to the minister, an elector would file an appeal in federal or provincial court. These appeals would be addressed by the courts, just as they are for federal, provincial, and municipal elections. This provision would minimize the potential for frivolous appeals and at the same time remove the minister from the process. Under the Indian Act, the same person can run for chief and for council in the same election. Not only can the same person run for both positions, the same person can be elected to and serve in both positions. That would change under Bill C-9. In addition, the Indian Act provides little guidance on other aspects of the nomination process. If they wish, for example, one person can nominate dozens or more candidates for any position. and it is not unheard of for a First Nation voter to be handed a ballot with more than 100 candidates listed on it, sometimes without the knowledge of those candidates. This hardly encourages citizens' engagement. That too would change under Bill C-9. The First Nations Election Act would enable First Nations to implement a more stringent nomination process. First Nations could impose a fee up to $250 to discourage the nomination of candidates who are not interested and are simply running as a lark. Under Bill C-9, First Nations would also have the authority to require all candidates nominated to accept their nomination in writing, so the names of people with no desire or interest do not appear on the ballot. In concluding, Mr. Speaker, I would point out that neither this provision nor anything else in this bill goes beyond what is the norm for most Canadians.
I'm rising to speak on behalf of New Democrats, and we will be opposing this bill. The member continues to emphasize this is an opt-in piece of legislation, but does not speak to the fact that the minister still has the power to force a First Nations, whether they're currently under the Indian Act or whether they're currently under a custom code election, to force that First Nations into the new Elections Act proposed under Bill C-9. And if the government were truly interested in moving away from a paternalistic approach, they would have actually moved towards something like a First Nations Elections Commission that would have removed that responsibility totally from the minister's hands. So they are not moving away from a paternalistic approach. They're continuing with that paternalistic approach, and that's evident in a number of clauses in this piece of legislation, and I'm going to touch on them. And I want to refer to a Senate report dealing with First Nations elections, and it gives a bit of a historical perspective, and I want to read this into the record. It says, the Indian Act's restrictive electoral system and imposition of federal control was widely resisted among Indian bands. Despite Indian opposition to the Indian Act system of elective government, attempts to suppress traditional forms of government continued. For example, in 1880, West Coast potlatches, an important means of affirming leadership and social order, were banned. And in the 1920s, the Canadian government jailed the traditional leaders of the Haudenosaunee and installed an Indian Act Council. The 1996 report of the Royal Commission on Aboriginal Peoples illustrated the difficulties experienced by Aboriginal peoples with respect to the imposition of the Indian Act elective system. The report concluded that for the past 100 years, the Indian Act has effectively displaced, obscured, or forced underground the traditional political structures and associated checks and balances that the Aboriginal people developed over the centuries to suit their societies and circumstances. Thus, the Indian Act electoral regime is rooted in a colonial mentality, and amendments to the Act from the perspective of First Nations do not erase colonial control over banned elections. And, Mr. Speaker, I would argue that this particular piece of legislation, despite the fact that it contains some things that First Nations wanted included, continues on that colonial mentality route. I want to turn to the Assembly of First Nations, and I think that they made a very good intervention. They say that the AFN supports enacting the full decision-making authority by First Nations governments empowered by their citizens. In choosing and designing mechanisms for the fulfillment of this authority, care needs to be taken that new barriers or new oversight mechanisms are not being created, further vesting control in the office of the Minister of Aboriginal Affairs and Northern Development. And of course, Mr. Speaker, as I pointed out in Clause 3, 1B and C, that continued ability of the minister to interfere and intervene is still there. In those Section 3B, the protracted leadership and the corrupt practices are not defined. And, Mr. Speaker, that does give the minister a fair bit of authority to determine who he or she will force under this new Election Act. This bill has a quasi-common day election that does not mirror the recommendations of the AMC. The bill does not achieve a common election day with the extended 4-year term for all Indian Act elections and does not give options for current custom election bands to opt into a common election day with the extended 4-year. The other piece that has caused concern for many First Nations is the restrictions of appeal process to external courts. Grand Chief Neepanak points out that this bill limits appeals to what it calls courts of competent jurisdiction and lists federal provincial courts as the only courts of competent jurisdiction. This bill ignores the rights of First Nations people to develop their own legal institutions, including a local appeal process. This bill ignores the AMC request for a local appeal process. This bill requires individuals to finance cost-prohibitive legal counsel and go to court for appeal rather than a less expensive and less complex and intimidating and local appeal process. The legislation mingles only one recommended change from the AMC and the illusion of another, and the resultant product is another piece of federal government-owned legislation that perpetuates Canada's self-proclaimed authority and chips away the rights of First Nations. Nothing in Bill C-9 talks about how First Nations will be consulted and accommodated with regards to developing the regulations, and this is a very important piece. So, Mr. Speaker, based on those facts, we cannot support this bill, and if the government wants to claim it's engaging in consultation, they must actually adhere to the principles around consultation, which means that they provide the resources, they provide the information, they listen, and then they actually take what they hear and make sure it's reflected in legislation that comes before this House. Thank you, Mr. Speaker.
And yet again, this government just can't help itself. It can't help itself put something in that just is totally unacceptable to the majority of First Nations in this country. Everybody is just asking them, take out these two sub-clauses and we would get on with finally a piece of legislation, First Nations led and supported by the House of Commons, that could have begun a process of First Nations being able to suggest and put forward legislation that Canada would expeditiously get through and support. It is the ultimate paternalism, these two sub-clauses that give the minister these unprecedented powers. In particular, Grand Chief Nepinak, Grand Chief of the AMC, has highlighted the minister's ability to bring First Nations under the legislation without their consent. But what is most appalling is Grand Chief Nepinak's first point, which was the minister's refusal to keep the bill truly optional, unlike how it was sold during the discussions with First Nations. In fact, Bill C-9 gives the Minister of Aboriginal Affairs broad discretionary powers that go against the opt-in nature of the legislation. The opt-in nature of this legislation had total support, and instead they have inserted these two clauses. In Clause 3.1b and c, it provides the minister with explicit powers to bring a First Nation currently under the Indian Act system or a custom code under C-9 when the minister finds that, in quotation, that a protracted leadership dispute has significantly compromised the governance of a First Nation, Clause 3.1b, and the Governor and Council has, under Section 79 of the Indian Act, set aside an election of a First Nations on the basis of the minister's finding of, quote, corrupt practice in connection with that election, end quote, Clause 3.1c. Given the opt-in nature of Bill C-9, it is completely unacceptable that the Conservative government has included a clause which provides the minister broad discretion to force First Nations under the Act. Forcing First Nations under an Act is not exactly opt-in. Opt-in is what First Nations agreed to in their support of this legislation. Now we have clauses that allow the minister to force a First Nation under C-9. This minister's power grab has turned what could have been a positive tool for First Nations governance into unnecessarily divisive legislation. This legislation was sold as purely opt-in during all of the consultations. The minister is essentially saying that unilaterally changing the fundamental character of the bill is acceptable if it gives him a better option when he decides to step in. This new optional legislation should not be used as a vehicle for the minister to have another option when imposing any electoral system on a First Nation. Further, The degree of discretion the minister has given himself is truly worrying. The terms, quote, protracted leadership dispute, end quote, and, quote, significantly compromised government, end quote, are not defined in the legislation. These terms, which trigger the minister's ability to impose the legislation, are therefore extremely broad in nature. This is clearly the ability of a minister to impose a set of rules on a First Nation that has not chosen to adopt them. This is therefore not opt-in legislation. This is not voluntary legislation. This is legislation which gives the minister the ability to force a First Nation under the power of this Act.